Hello students, I hope that you're all doing fine. In this 14th lecture of this certification course, we're going to continue with time for performance and finish the concept of impossibility of performance as mentioned under section 56 of Indian Contract Act of 1872. So let's begin. So sometimes the parties to a contract specify the time for its performance. Ordinarily, it is expected that either party will perform his obligation at the stipulated time. But if one of them fails to do so, the question arises, what is the effect upon the contract? So section 55 contains the answer. It says, effect of failure to perform at fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract, or so much of it as has not been performed, becomes voidable at the option of the promisee if the intention of the parties was that time should be of the essence of the contract. So, effect of such failure when time is not essential is also mentioned under section 55. It says, if it is not the intention of the parties that time should be of the essence of the contract, then the contract does not become voidable by the failure to do such thing at or before the specified time. But the promisee is entitled to compensation from the promiser for any loss occasioned to him by such failure. And it says, effect of acceptance of performance at time other than that agreed upon. If, in case of a contract voidable on account of the promiser's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than that agreed, the promisee cannot claim compensation for any loss occasioned by the non-performance of the promise at the time agreed, unless at the time of such acceptance he gives notice to the promiser of his intention to do so. So, following are some factors which make time of essence. According to this section, if the intention of the parties was that time should be the essence of the contract, then a failure to perform at the agreed time renders the contract voidable at the option of the opposite party. Time is generally considered to be of the essence of the contract in the following three cases. Number one, where the parties have expressly agreed to treat it as of the essence of the contract. Number two, where delay operates as an injury. And number three, where the nature and necessity of the contract requires it to be so construed. For example, where a party asks for extension of time for performance. So, in the well-known case of Budra Chand versus Betts, the facts were such that the plaintiff stipulated with the defendant to engage his elephant for the purpose of kheda operations. The contract provided that the elephant would be delivered on the 1st October 1910, but the defendant obtained an extension of time until the 6th of October and yet did not deliver the elephant till the 11th. So the plaintiff here refused to accept the elephant and sued for damages for the breach. Here, he was held entitled to recover as the parties intended that time should be of the essence of the contract, and this conclusion is confirmed by the circumstance that the defendant obtained an extension of the time. If the time were not of the essence of the contract, he would have not asked for extension of time. Further, in the case of Man Kaur versus Hartar Singh Sangha, the Supreme Court held that the time of performance was extended by the parties and therefore it was not to be considered as of the essence of the contract. So, there are some consequences of failure. Section 55 declares that if it was not the intention of the parties that time should be of the essence of the contract does not become voidable by the failure to do such things at or before the specified time. It means that the innocent party will have to accept performance even if it is delayed. He does not have the right to reject, but he may sue the other party for any loss caused by the delay. In McDermott International Incorporated versus Burns Standard Co. Limited, there was some delay on the part of a contractor to supply to the State Electricity Board certain goods by the prescribed date, and the court, finding no evidence whatsoever of the party's intention to regard time as of essence, held that the board was bound to accept delayed deliveries. The right to recover compensation for the delay would be there. The Supreme Court has held that no notice would be necessary for exercising the right to seek compensation. In State of Andhra Pradesh versus Associated Engineering Enterprises, where On the other hand, the time of performance was of the essence of the contract. Then any delay here rendered the contract voidable at the option of the other party. He could reject the performance and immediately sue for the breach. But he could, at his option, also accept the delayed performance. And in such a case, if he did so, he could not afterwards recover compensation for the delay, unless at the time of such acceptance he gave notice to the promisor of his intention to do so. Now, starting with one of the most important sections of Indian Contract Act of 1872, that is section 56. The number of questions, both pre and mains, that have been asked in UPPCSG examination on this given section, it's simply exemplary, and we're going to see the same in a few minutes. So it says, agreement to do impossible act. An agreement to do an act impossible in itself is void. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful. Where one person has promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful, such promisor must make compensation to such promisee for any loss which such promisee sustains through the non-performance of the promise. It has illustrations. A agrees with B to discover treasure by magic. The agreement is void. A and B contract to marry each other. Before the time fixed for the marriage, A goes mad. The contract becomes void. A contracts to marry B, being already married to C, and being forbidden by the law to which he is subject to practice polygamy. A must make compensation to B for the loss caused to her by the non-performance of his promise. A contracts to take in cargo for B at a foreign port. A's government afterwards declares war against the country in which the port is situated. The contract becomes void when war is declared. A contracts to act at a theatre for 6 months in consideration of a sum paid in advance by B. On several occasions, A is too ill to act. The contract to act on those occasions becomes void. So a question was asked in UPPCSG 2012, with which we are going to start with the literature on this section. The question said, an agreement to do an impossible act in itself is, and as you must already realize by now, it is void. So a question was asked in UPPCSG 2015, it was a mains question, and it said, the sanctity of a contract is the foundation of the law of contract, and the doctrine of impossibility cannot be permitted to become a device for destroying that sanctity. Explain this statement. So by the time we are done with this section, I am sure you would be able to answer this question. While we go through this section, keep this question in mind. Now, starting with the general principle of judicial non-interference. In the first known English case of Paradine versus Jane, it was pointed out that subsequent happenings should not affect a contract already made. There, the defendant had taken an estate on lease from the plaintiffs. The defendant was dispossessed of it by alien enemies for some time and therefore refused to pay the rent for the period of dispossession. It was held that when the party by his own contract creates a duty, he is bound to make it good, if he may, and notwithstanding any accident by inevitable necessity, because he might have provided against it by his contract. Though the land be surrounded or gained by the seas or made barren by wildfire, yet the lessor will have his whole rent. In the subsequent case to Taylor versus Caldwell, Justice Blackburn laid down that the above rule is only applicable when the contract is positive and absolute and not subject to any condition either express or implied. In this case, the defendants had agreed to let the plaintiffs the use of their music hall between certain dates for the purpose of holding a concert there. But before that first day on which a concert was to be given, the hall was destroyed by fire without the fault of either party. The plaintiffs sued the defendants for the loss. It was held that the contract was not absolute, as its performance depended upon the continued existence of the hall. It was therefore subject to an implied condition that the party shall be excused in case, before breach, performance becomes impossible from the perishing of thing without default of the contractor. With this decision, began the struggle between the two principles, namely the principle of sanctity of contract, which supports the principle of absolute liability, and the principle that a contract be discharged when the shared contractual assumption has been destroyed by change of circumstances. So, beginning with the idea of frustration. In Taylor versus Caldwell, the performance of the contract had become physically impossible because of the disappearance of the subject matter. But the principle is not confined to physical impossibilities. It extends also to cases where the performance of the contract is physically possible, but the object of the parties the object that the parties had in mind has failed to materialize. So the well-known coronation cases, of which Krell versus Henry is one, illustrates this. In this case, the defendant agreed to hire from the plaintiff a flat for June 26 and 27, on which days it had been announced that the coronation procession would pass along that place. A part of the rent was paid in advance, but the procession having been cancelled owing to the king's illness, the defendant refused to pay the balance. So it was held that the real object of the contract, as recognized by both contracting parties, was to have a view of the coronation procession. The taking place of the procession was therefore the foundation of the contract. The object of the contract was frustrated by non-happening of the coronation, and the plaintiff was not entitled to recover the balance of the rent. So that the doctrine of frustration comes into play in two types of situations. First, where the performance is physically cut off, and second, where the object has failed. The Supreme Court of India has held that Section 56 will apply to both kinds of frustration. Referring to the section, the Supreme Court observed in the landmark case of Satyabrata Ghosh versus Mugniram Bangur and Co. as follows. This much is clear that the word impossible has not been used here in the sense of physical or literal impossibility. The performance of an act may not be literally impossible, but it may be impracticable and useless from the point of view of the object and purpose which the parties had in view. And if an untoward event or change of circumstances totally upsets the very foundation upon which the parties rested their bargain, it can very well be said that the promisor finds it impossible to do the act which he promised to do. So a question was asked in UPPCJ 2003, which of the following cases related to doctrine of frustration? And the answer, as you must know by now, is Satyabrat Ghosh versus Mugniram. The same question was asked in UPPCJ 2015. Satyabrat Ghosh versus Mangiram Bongar is a case on frustration. So, a question was asked, a mains question, in UPPCJ examination of 1999. It said, initial impossibility renders an agreement void and subsequent impossibility renders a contract void. Discussed with reference to the provisions of Indian Contract Act of 1872 and decided cases. So here, students, we had to mention the definition of doctrine of frustration under section 56 of Indian Contract Act of 1872 and then substantiate it with case laws of Satyabrat Ghosh, Krell versus Henry, Paradigm versus Jain and Taylor versus Caldwell. That would have answered the question aptly. Further, in UPPCH examination 2000, a very general question was asked, explain the doctrine of frustration. So seeing how general this question was, I'm sure that basing this answer to that of last question that we just discussed, you would have answered this question aptly. Further, in UPPCJ examination of 2018, so you can see how often questions have been asked on this given topic. As recently as in 2018, question was asked, discuss in brief the doctrine of frustration as applicable in India and state the specific grounds of frustration of contract. Refer to statutory provisions and decided cases wherever relevant. So as opposed to the other questions which were general in nature, especially the last one, this particular question is a bit specific. So by the time we're done with the following part, I'm sure you'll be easily able to answer this question. Now, starting with the specific grounds of frustration. The principle of frustration of contract or of impossibility of performance is applicable to a great variety of contracts. It is therefore not possible to lay down an exhaustive list of situations in which the doctrine is going to be applied so as to excuse performance. Yet, the following grounds of frustration have become well established. So, the first one is destruction of subject matter. The doctrine of impossibility applies with full force where the actual and specific subject matter of the contract has ceased to exist, and Taylor versus Caldwell is the best example of this class. There, a promise to let out a music hall was held to have frustrated on the destruction of the hall. The second ground is that of change of circumstances. As held in Joseph Constantine Steamship Line Limited versus Imperial Smelting Corporation Limited, a contract will frustrate where circumstances arise which make the performance of the contract impossible in the manner and at the time contemplated. Another ground is that of non-occurrence of contemplated event. Sometimes the performance of a contract remains entirely possible, but owing to the non-occurrence of an event contemplated by both parties as the reason for the contract, the value of the performance is destroyed. Feld versus Henry is an apt illustration on this. There, a contract to hire a room to review a proposed coronation procession was held to have frustrated when the procession was postponed. For this result to follow, it is necessary, however, that the happening of the event should be the foundation of the contract. The fourth ground is that of death or incapacity of party. So a party to a contract is excused from performance if it depends upon the existence of a given person, if that person perishes or becomes too ill to perform. Thus, where the nature or terms of a contract require personal performance by the promisor, his death or incapacity puts an end to the contract. And Robinson versus Davison is a well-known authority here. Here the fact was that there was a contract between the plaintiff and the defendant's wife, who was an eminent pianist, that she should play the piano at a concert to be given by the plaintiff on a specified day. On the morning of the day in question, she informed the plaintiff that she was too ill to attend the concert. The concert had to be postponed and the plaintiff lost a sum of money. The plaintiff's action for breach of contract failed. The court said that under the circumstances she was not merely excused from playing, but she was also not at liberty to play if she was unfit to do so. The contract thus was clearly subject to the condition of her being well enough to perform. The whole contract is based on the assumption of the continuance of life and on the conditions which existed at the time. That assumption is made by both. It is really the foundation of the contract. So, it does not require close reasoning to prove that if the foundation fails, the whole contract must fail. Here, the foundation was wanting, for there was on Mrs. Davison's part an entire and total incapacity to do the thing contracted for. Now, the fifth ground is that of government administrative or legislative intervention. As held in Blackburn, Bob & Co. versus T.W. Allen & Sons, a contract will be dissolved when legislative or administrative intervention has so directly operated upon the fulfillment of the contract for a specific work as to transform the contemplated conditions of performance. Further, in the case of Shyam Sundar versus Durga, where a vendor of land could not execute the sale deed because he ceased to be the owner by operation of law, it was held that the contract had become impossible of performance. So the effect of an administrative intervention has to be viewed in the light of the terms of the contract, and if the terms show the parties have undertaken an absolute obligation regardless of administrative changes, then they cannot claim to be discharged. This has been so held by the Supreme Court in Nehati Jute Mills Limited versus Khyaliram Jagannath, whereby there was an agreement to purchase raw jute to be imported from East Pakistan. The buyer was to supply the import license within November, failing which it was supposed to be supplied within December at the pain of a little more price, and if he failed in December, he was to pay the difference between the contract and the market prices. So the buyer applied for a license which was refused because he had stock in his mill sufficient for 2 months. He applied again. He was advised this time that the rules had been changed and to obtain a license he must show that he had used an equal quantity of Indian jute. Thus the buyer failed to supply the license and was sued for breach. He pleaded frustration caused by the change in government policy, but he was held liable. Here, Justice Sheleth pointed out that if the government had completely forbidden imports, Section 56 would have applied. But the policy of the government was that the licensing authority would scrutinize the case of each applicant on its own merit. So, referring to the terms of the contract, the learned judge said, these clauses clearly indicate that the applicants were conscious of the difficulty of getting the license in time. So the question would depend upon whether the contract which the applicants entered into was that they would make their best endeavors to get the license, or whether the contract was that they would obtain it or else be liable for breach of that stipulation. So there is nothing improper or illegal for a party to take upon himself an absolute obligation to obtain a permit or a license, and in such a case, if he took the risk, he must be held bound to his stipulation. Further, intervention of war is another ground. Intervention of war or warlike conditions in the performance of a contract has often created difficult questions. For example, the closure of the Suez Canal following the Anglo-French War with Egypt interrupted the performance of many contracts. One such case was that of Sakioro Glow and Co. Limited versus Nobly and Thord. Here, Lord Reid said, the applicants agreed to sell to the respondents 300 tons of Sudan groundnuts. The usual and normal route at the date of the contract was via Suez Canal. Shipment was to be in November-December 1956, but on November 2, 1956, the canal was closed to traffic and it was not reopened until the following April. It is stated that the applicants could have transported the goods via the Cape of Good Hope. The applicants refused to ship the goods via the Cape, and now the question is whether by reason of the closing of the Suez route, the contract had been ended by frustration. The applicant's argument in this case was that it was an implied term of the contract that the shipment should be via Suez. But it was held that such a term could not be implied. Because the customary or usual route via the Suez Canal being closed, the applicants were bound by the Sales Goods Act 1893 to ship the groundnuts by a reasonable and practical route, and though the applicants might be put to greater expense by shipping the groundnuts via the Cape of Good Hope, that did not render the contract fundamentally or radically different, and there was not frustration of the contract. Now, the case of Gambhir Mul Mahabir Prasad versus Indian Bank Limited presents a different story, where it was held that if the intervention of war is due to the delay caused by the negligence of a party, then the principle of frustration cannot be relied upon. Now, in relation to application to leases, which is another ground for this doctrine, now another ground is that of application to leases. So, firstly, in relation to English cases, the question whether the doctrine of frustration applies to a lease of land is not yet finally settled in England. In the leading case of Cricklewood Property and Investment Trust Limited versus Leighton's Investment Trust Limited, which came before the House of Lords, the decision was unanimous that on the facts of the case, irrespective of any controversy, frustration would not have arisen because a lease for 99 years cannot be said to have been upset by a few years' disturbance. But contradictory opinions were expressed. Here, a building lease was executed for 99 years, more rent being payable after erection of buildings. But before any could be erected, and while the lease had still 90 years to run, building activity was suspended by the government because of the war. So here, learned judge Viscount Simon said, the lease at the time had more than 90 years to run, and though we do not know how long the present war and the emergency regulations which have been made necessary by it are going to last, length of the interruption so caused is presumably a small fraction of the whole term. Here, the lease itself contemplates that rent may be payable although no building is going on, and I cannot regard the interruption which has arisen as such as to destroy the identity of the arrangement or to make it unreasonable to carry out the lease according to its terms as soon as the interruption in building is over. But his lordship was not prepared to accept the view that because a lease is more than a contract and amounts to an estate, therefore it can never end prematurely by frustration. For example, where the subject matter of the lease is swallowed by some vast concussion of nature or buried in the depth of the sea. Suppose, for example, his lordship continued, that legislation were subsequently passed which permanently prohibited private building in the area, or dedicated it as an open space forever. Why should this not bring to an end the currency of a building lease, the object of which is to provide for the erection of the area for the combined advantage of the lessor and lessee of buildings which it would now be unlawful to construct. So, referring to the previous authorities, Viscount Simon characterized it as erroneous to suppose that there is authority binding on the House of Lords to the effect that the lease cannot in any circumstances be ended by frustration. Now, talking about the same idea in relation to Indian cases, we see that in India the question was considered by the Supreme Court in the case of Raja Dhruv Dev Chand versus Raja Harmobinder Singh, where Justice Shah observed, authorities in the courts in India have generally taken the view that Section 56 of the Contract Act is not applicable when the rights and obligations of the parties arise under a transfer of property under a lease. It was one of the cases arising out of the partition of the country into India and Pakistan. So the lease in question was that of an agricultural land for 1 year only. The rent was paid and the lessee was given possession. Before the land could be exploited for any crops came partition, which left the land in Pakistan and the parties migrated to India. The action was to recover the rent paid. But here, in this case, no such recovery was allowed, and Justice Shah spoke on behalf of himself and Justice Ramaswamy and Justice Mittal when he said that completed transfers are completely outside the scope of Section 56. So now that we're done with the grounds of doctrine of frustration, we're going to talk about the theories of frustration. Now, there are basically two theories of frustration, and the first one is that of theory of implied term. It was explained by Lord Loreburn in the famous case of E.A. Tamplin Steamship Co. Limited versus Anglo-Mexican Petroleum Products Co. Limited. He explained the given principle in the following words. A court can and ought to examine the contract and the circumstances in which it was made, not of course to vary, but to explain it in order to see whether or not, from the nature of it, the parties must have made their bargain on the footing that a particular thing or state of things would continue to exist. And if they must have done so, then a term to that effect will be implied, though it be not expressed in the contract. It is in my opinion the true principle, for no court has absolving power, but it can infer from the nature of the contract and the surrounding circumstances that a condition which was not expressed was a foundation on which the parties contracted. Were the altered conditions such that had they thought of them, they would have taken their chances of them, or such that as sensible men they would have said, if that happens, of course, it is all over between us. Now, this explanation of the doctrine of frustration has been constantly cited in a large number of decisions, but it has also been criticized as something unreal. For instance, Lord Wright, in the case of Denny Mott and Dickinson Limited versus James Bay Fraser and Co. Limited, said, to my mind, the theory of the implied condition is not really consistent with the true theory of frustration. It has never been acted on by the court as a ground of decision, but is merely stated as a theoretical explanation. So, the second theory of this given doctrine is that of just and reasonable solution. It was formed by Lord Learned Judge Denning in the case of British Movie to News Limited versus London and District Cinemas Limited. And here, the given lord attempted to explain the doctrine of frustration on a different basis. He said, the court really exercises a qualifying power, a power to qualify the absolute, literal or wide terms of the contract, in order to do what is just and reasonable in the new situation. The day is done when we can excuse an unforeseen injustice by saying to the sufferer, it is your own folly, you ought not to have passed that form of words, you ought to have put in a clause to protect yourself. We no longer credit a party with the foresight of a prophet or his lawyer with the draftsmanship of a Chambliss. But this statement was not approved when the case went before the House of Lords. The observation of Lord Loreburn that no court has an absolving power was re-emphasized. Viscount Simon said the principle remains the same. Particular applications of it may greatly vary, and theoretically lawyers may debate whether the rule should be regarded as arising from implied term or because the basis of the contract no longer exists. In any view, it is a question of construction, as Lord Wright pointed out in the case of Joseph Constantine Steamship Line Limited versus Imperial Smelting Corporation Limited, and as has been repeatedly asserted by other masters of law. Now, these theories are not applicable in India. Referring to the theories, Justice B.K. Mukherjee of the Supreme Court has said in the case of Satyavrata Ghosh versus Mugniram Bangur and Co. These differences in the way of formulating legal theories really do not concern us so long as we have statutory provision in the Indian Contract Act. In deciding cases in India, the only doctrine that we have to go by is that of supervening impossibility or illegality as laid down in Section 56 of the Contract Act, taking the word impossible in its practical and not literal sense. It must be borne in mind, however, that Section 56 does lay down a rule of positive law and does not leave the matter to be determined according to the intention of the parties. Now, lastly, talking about the effects of frustration. As held in the case of Denny Mott and Dickinson Limited versus James B. Fraser Co. Limited, it is well settled that if and when there is frustration, the dissolution of the contract occurs automatically. It does not depend, or as does rescission of a contract, on the ground of repudiation or breach, or on the choice of election of either party. It depends on the effect of what has actually happened on the possibility of performing the contract. So the first effect is that frustration should not be self-induced. In Maritime National Fish Limited versus Ocean Trawlers Limited, the facts were the appellants hired the respondent's trawler called the St. Cuthbert to be employed in fishing industry only. Both parties knew that the trawler could be used for that purpose only under a license from the Canadian government. The appellants were using 5 trawlers and they were applied for 5 licenses. Only 3 were granted and the government asked the appellants to name 3 trawlers and they named trawlers other than the St. Cuthbert. They then repudiated the charter and pleaded frustration in response to the respondents' action for the hire. Here, as a response to this, the Judicial Committee of the Privy Council held that the frustration in this case was the result of the appellant's own choice of excluding the respondent's ship from the license and therefore they were not discharged from the contract. The second effect is that frustration operates automatically. As held in the case of Dahl versus Nelson, the legal effect of frustration does not depend on their intention or their opinions or even knowledge as to the event. Further, it has been held in the case of Satyavrat Ghosh versus Mugniram Bangur and Co. that the belief, knowledge and intention of the parties are evidence, but evidence only on which the court has to form its conclusion whether the changed circumstances destroyed altogether the basis of the adventure and its underlying object. This is particularly true of Indian law as Section 56 of the Contract Act lays down a rule of positive law and does not leave the matter to be determined according to the intention of the parties. So as you must realize by now, this given case is very important. Now lastly, the third effect is that of adjustment of rights. The rights of the parties are adjusted under Section 65 of the Indian Contract Act. It says, obligation of parties who has received advantage under void agreement or contract that becomes void. When an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. It has 4 illustrations whereby A pays B rupees 1,000 in consideration of B's promising to marry C, A's daughter. C is dead at the time of the promise. The agreement is void, but B must repay A the 1,000 rupees. A contracts with B to deliver to him 250 mons of rice before the 1st of May. A delivers 130 mons only before that day and none after. B retains the 130 mons after the 1st day of May. He is bound to pay A for them. A singer, contracts with B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months, and B engages to pay her 100 rupees for each night's performance. On the 6th night, A willfully absents herself from the theatre and B, in consequence, rescinds the contract. B must pay A for the 5 nights on which she had sung. A contracts to sing for B at a concert for 1,000 rupees which are paid in advance. A is too ill to sing. A is not bound to make compensation to B for the loss of the profits which B would have made if A had been able to sing, but must refund to B the 1,000 rupees paid in advance. Now, in relation to this section, a question has been asked repeatedly in UPPCSJ 2003, UPPCSJ 2012, that the rule enunciated by Section 65 of the Indian Contract Act of 1872 is applicable to agreements which are reduced void by. The answer was impossibility of performance of contract, as you must understand after reading the given section. Now, it has been held in the case of Amri Devi versus Ridmal that the effect of the principle laid down in the section is that when the parties have entered into an apparently valid contract and some benefits have been passed under it, and subsequently the contract is either discovered to be void or becomes void, the party who has received the benefits must restore them to the other. Thus, the section does not apply to a contract which the parties knew at the time of making it to be void. The section also does not apply to a case where the parties are passed at a time when the contract has, though unknown to the parties, already ceased to be enforceable. This was the position in the case of Jagdish Prasad Pannalal versus Produce Exchange Corporation Limited. So the fact was that there was a contract for the sale of 1 wagon of maize starch at the rate of Rs 77 per CWT, the control price being Rs 78. The goods were delivered on January 3 and paid for. A few days earlier, viz. On December 16, a new order was passed by the government making Rs 48 as the price, and this was to apply to all contracts in which delivery was to be given on or after January 1. The buyer bought an action to recover the difference between the revised control price and the price he paid. The court agreed with him to this extent that the contract had become void by the change in the control price, and therefore neither party was compellable to perform, but that the buyer, having paid up, was not entitled to any refund under Section 65. For this section to apply, the advantage must have been received under contract, whereas in the present case, the excess price was paid after the contract had become void and ceased to be enforceable. So, on the idea of discovered to be void, the first part is concerned with an agreement which never amounted to a contract, it being void ab initio. But the parties discovered this at a later stage. The word discovered connotes the pre-existence of that which is discovered. So this will cover cases of initial mistake, where for example money is paid for the sale of goods, which unknown to the parties have already perished at the time. The money is refundable, and as held in Uttam Chand versus Mohandas, this principle will apply whether the agreement is void by reason of law or by reason of facts. Now, the idea of pari delicto. It is a principle which has also been held to apply in cases where a contract is void by reason of unlawful object, but the parties were not aware of it. Thus, for instance, in Ram Singh versus Jetanan Vadumal and Co., whereby the parties made a forward contract in hydrogenated groundnut oil, not aware of the existence of an order issued under the Defence of India rules prohibiting such contracts, the court held that the parties are not in pari delicto, and therefore it is a contract which is subsequently discovered to be void. The purchaser who has advanced money under the contract is entitled to a refund of it. The doctrine of pari delicto was stated in the following words in Onkarmal versus Banwan Laya. The principle behind the doctrine of pari delicto, as the court held, is that where each party is equally at fault, the law favors him who is actually in possession, or that where both parties are equally culpable, the law will leave them where it finds them and will not engage itself to determine the rights as between them. But this principle is subject to well-known exceptions, one of which is that it will not apply where the parties are not or cannot be said to be really in pari delicto. Thus, there are at least two exceptions in which the benefits passed under an agreement which is void by reason of illegality of object can be recovered. Firstly, where the parties are not at equal fault, the less guilty may recover anything that he has given to the other under the contract. So in the case of Hughes versus Liverpool Victoria Legal Friendly Society, where a woman was induced by an insurance agent to pay premium upon an illegal and void policy, she was held entitled to recover as he was innocent. The doctrine of pari delicto is not designated to reward the wrongdoer or to penalize the wrong by denying to the victim access to justice. The doctrine is attracted only when none of the parties is a victim and both parties have voluntarily and by their free will joined hands to flout the law for the mutual gain. Applying this principle to the landlord-tenancy relationship, Justice Thakkar of the Supreme Court, in the case of Muhammad Salimuddin versus Misri Lal, has held that advancing a sum of money by way of loan by the tenant to the landlord in order to get possession of premises under an unlawful agreement is an exploitation of a needy person, and therefore here he was entitled to have the advance adjusted towards rent as agreed. Secondly, where no part of the illegal purpose has been executed, that is, the agreement is still executory, then any benefits passed under the agreement may be recovered back. In the case of Dharinder versus Kanji Sahai, wherein a contract of marriage which was illegal, the father of the bride refused to perform the marriage, he was held entitled to the refund of the money paid by him to the father of the bridegroom. Now lastly, talking about the principle of quantum merit claims. So claims under the well-known English law doctrine of quantum merit have been allowed by the courts under this given section. The Supreme Court of India has observed in the case of State of Madras versus Gannon Durkernley Co. that a claim for quantum merit is a claim for damages for breach of contract. The value of the material used or supplied is a factor which furnishes a basis for asserting the amount of compensation. The claim is not for price of goods sold and delivered, but for damages. That is also the position under section 65. Now, talking about the second type of situation as given under section 65, that is becomes void. So, where a valid contract is made in the beginning but it subsequently becomes either unlawful or impossible of performance, any benefit which have been passed under the contract from one party to the other must be restored. This, however, is subject to the expenses which have already been incurred by the other party in the performance of the contract. In the case of Pallava Granite Industries India versus AP Mineral Development Corporation, where a contract for purchase of granite stones became inoperative by reason of the seller's delay in obtaining permit from the mining department for removal of the material, the purchaser became entitled to refund of the whole of the money paid by him, and no interest was allowed because he had himself deposited the money with some delays. So a question has also been asked on this given topic in UPPCJ 2006 that said, a right to sue on quantum merit arises from, and the answer was when a party performed the contract and is discharged by the other party. That sums up this lecture, students. In the next lecture, we are going to continue from appropriation of payments and finish discharge by agreement. Thank you. Take care.